sit there at the end.
Yes, yes, good, yes. We met before.
Are we expecting anybody else from either side?
Not from the city.
Okay, I don't think so.
Are you guys expecting anybody else?
No,
Is that a yes or a no?
no.
Okay.
Everybody ready to go? Okay. All right, good morning, everyone. I'm Brian McGinn, the city's hearing examiner. My assistant is Leanne Reed. For the record, today is July 12, 2016. It's about 10 a.m. We're located in the City Council Briefing Center conference room, located in the lower level of City Hall. The item scheduled to be heard at this time is an appeal of a decision by the city's tax and licensing department denying an application for an entertainment facility license. Pendleton Enterprises LLC applied for the license for the business operating as the Spokane Downtown Daiquiri Factory, located at 121 North Wall Street in the city of Spokane, Washington. The appellant is Pendleton Enterprises LLC. The appeal was filed by Jacqueline Pendleton on behalf of the LLC. The respondent is the city of Spokane, which is represented by Timothy Zamblin and Matthew Folsom, assistant city attorneys. The matter is designated under hearing examiner file number AP-16-01. If the parties prefer a different procedure to be followed, let me know, but my preference would be to follow the process I'm about to describe. First, we'll have the appellant, Pendleton Enterprises LLC, present its arguments and evidence in support of its appeal. Next, we'll have the respondent, City of Spokane, present its arguments and evidence defending the decision and in response to the appeal. Each party would be allowed some time for rebuttal arguments. And finally, the appellant will have the last word in the proceedings. The reason I reference, they may have different preference. I don't know if the parties have decided on another process or have decided to prepare opening statements and that sort of thing. But for simplicity's sake, that's the process I would suggest. This is an open record hearing. Parties are free to present whatever evidence is relevant in the remaining proceedings. To my knowledge, there was no previous hearing to this one, so there's no prior established record upon which to decide the appeal. However, it is an appeal hearing, and as such, generally won't accept public testimony. In other words, only witnesses called by a party may testify in the matter. Parties can also call expert witnesses if they so desire. I've reviewed the documents supplied to me by the parties, including the materials submitted yesterday, July 11, 2016. Those documents included the brief in support of the denial of the entertainment facility license submitted by Mr. Zamblin, the documentation regarding civil infractions supplied to this office by Mr. Folsom, as well as the email response from Ms. Pendleton commenting on the civil infraction documents primarily. All those documents are part of the record of the proceedings. When decisions are in writing, I don't make them at the hearing, but under the hearing examiner ordinance, I have 10 days to get them done. At this point, since we've already had some controversy about the veracity of some of the statements being made, I'm going to have everyone who's planning to testify under oath. So, who are the parties that are going to be testifying today? I know the attorneys aren't, but okay, so we got four people. All right, so all of you raise your right hand and together. I'm going to swear you all in. So, do you swear from the testimony you're about to give will be the truth?
I do.
Okay, so let the record reflect that everyone who's going to testify has taken the oath and answered the oath in the affirmative. All right, so that's generally the process for today. Are there any questions about procedure at this point? Does it all make sense? All right, good enough. Then I guess, Mr. Pendleton, I guess. No?
I can start off.
All right, very good.
The only thing I would add before we start.
Yes.
Your Honor, sorry to interrupt, Mr. Pendleton, this is Matt Olson from the city of Spokane. We would make a motion at this time to exclude fact witnesses. Presiding officer may order the exclusion of witnesses upon a showing of good cause. We have, I think, good cause shown here by the fact that we would like each witness to provide their own testimony, not testimony that is colored or tainted by the proceedings here or by other testimony. It's pretty common practice in criminal prosecutions. This is obviously not that, but I think it would be valuable here.
Okay. Mr. Pendleton, do you understand the motion?
I would motion to object that this is not a superior court. This is a hearing. And just like we've been able to provide evidence here, we should be able to provide our witnesses as well. That's what they're here for.
And absolutely every witness would be allowed to come in and testify. They would just not be.
Right,
in
the
the
motion
part.
would be that the witnesses wait in the hall, basically, until their time to testify. How many witnesses do you plan to call?
I have one.
Just the one. What's your name, sir?
Chad Patrick.
Okay, all right. Just thinking for a moment whether that's necessary or not. Now, this is a pretty informal process. I think at this point we'll just have the witnesses in the room. Well, I'm hesitating because there is a civil infraction component to this.
But it is a public hearing.
It is a public hearing. That's not really the question. It would be open to the public. The question is whether the witnesses will be influenced by the testimony that others provide. You make a fair point, Mr. Folsom, but I think I'm going to just proceed with the witnesses in the room.
Thank you, Your Honor.
All right. All right, Mr. Pendleton, go ahead.
Thank you, Your Honor. Let me first open by saying an entertainment license is not required to operate a food drink establishment in the city of Spokane. A business license, a health permit, an occupancy permit, a fire assembly permit is required, which the business does have and we had established before reopening the establishment in 2016. The business willfully applied for application for entertainment license in a timely manner. It had no reason to think or assume the license renewal would be denied. Business followed section 1023A 020 of SMC and followed the application procedure in section 04.04.030 of the Spokane Municipal Code. Business had applied for all proper sidewalk cafe, health license, business license, fire department assembly, and new occupancy license for the business. All these licenses were approved by the same city officials that are now wishing to deny license for the plain fact that it was not received prior, but offer no reason why the appellant would think the renewal would not be approved. Respondent cites no reason that Spokane police have to deny the entertainment license. Respondent has violated section 04.04.050B that lists the powers to refuse to issue a license. Respondent Officer Robridge chose to open an incident report and report the business operating to use it as a reason to later deny the issuance of a license. This is not a reason to refuse issue of license. Here I've got a copy of the incident report that is public record of Officer Robridge.
Okay, hold on. Can you take a look at that? Mr.
Yeah,
Folsom?
that is the opening of the incident report. It's public record that we received yesterday from the city of Spokane. That shows Officer Robridge doing the dispatch to open up the incident complaint and closing the complaint. That's a public record.
Okay,
provided by the
hold on
city.
right there, please. Thank you.
Mhm.
objection to the omission of this?
No objection.
All right, we're gonna admit this incident report printout as the first exhibit. All right, go
If I may
ahead.
continue.
Sure.
The respondent spends great length in its reply brief looking for a reason to deny the license. On June 7th, June 10th, and June 14th, officers reported to Michael Robridge and other city officials that music was being played from the venue. But at no time did any officer write a citation. No opportunity to comply was given. No offer to comply was given. If you look at the incident report that was submitted yesterday, Officer Robridge cites every single incident that happened and cites every single witness, but at no point of time did he cite that any officer wrote a citation. Then later, after the notice of appeal was filed and received on 6/21, a supplemental report was written by Officer Robridge, stating that he was advised by the Spokane City Prosecutor to assist the Spokane Taxes and License Clerk, M. Red, in fixing an infraction for compliance with the municipal clerk. The prosecutor advised that the initial citation would be voided and separate citations should be issued. No initial citation was noted in his incident report, which covers the dates of 6/8 through 6/14. In the documents that they gave to you yesterday by email, it shows 3 separate citations for Sabrina Thompson, Jacqueline Pendleton, and Jamie Pendleton. Only Jacqueline Pendleton and Sabrina Thompson are officers of the LLC. That's a matter of public record. It's available on the state of Washington website if you look up the LLC. Nowhere in the municipal code does it state that each officer of the LLC would be cited if you look at the municipal code and the penalties for operating. But still, these 3 citations were instructed by the prosecutor to be written. The prosecutor states in this supplemental report, written by Officer Robridge under the penalty of perjury, that the initial citation would be voided. There is no initial citation on municipal court records. The only tickets written were on 6/29, and if you look at the date stamped on these tickets, they were filed 6/29 as well. Approximately 7 days after our hearing, notice of hearing was filed. City Municipal Code states specific procedures order to comply. Respondent did not follow municipal code to issue a order to comply. The respondent wishes to offer a leaving of a voicemail as a order to comply. At no time did respondents write a citation. Officers are on location according to his incident report on several occasions. No citation was written. No citation was noted in the incident report by Michael Robridge. Respondents spent great length stating the violations that they did not write citations for. Then later, after they receive a notice of appeal from hearing examiner, they add a supplemental report to the original report stating citations exist. Citations that were revealed for the first time to the appellant yesterday. I'm not sure what the procedure is for the city, but if you look at the notes on the tickets submitted yesterday, it said sent to the court for mailing. As of today's date, Sabrina Thompson, Jacqueline Pendleton, and myself, Jamie Pendleton, have not received these tickets. They're clearly written, they're clearly filed. When you do a search on the website for the municipal court, they're there, but we haven't received them. We received a copy of them yesterday. We have no notice of when the court dates are for these citations. All we have is the information that was provided yesterday. Also, please note that these fees on the tickets are $513 on each ticket are not in the municipal code as penalty nor does the municipal code state that all members of the LLC be issued a citation or employees of the LLC be issued a citation. Great effort is being used to paint a picture of wrongdoing in this matter. Respondents went through great lengths on their brief to show that Michael Roberts took care in creating these incident reports. But at no time do the respondents make notes that Michael Roberts came to the location. On 6/26, this is surveillance video of Michael Roberts entering the premises. We've archived the full video if we need to provide that at a later date.
Hold on a second now, please.
Problem.
Is there any objection to the admission of this?
I'd like to hear a little more foundation.
All right. Can you explain how this video was taken, when it was taken?
Video surveillance is provided by AT of the premises 24 hours a day. Not only do I have video, I have a witness here that was on site at the same time.
All right, so again.
The reason why,
Sorry, hold on. Who took the video?
ADT, I have security
ADT,
cameras
all right.
that roll 24 hours a day on the
And
premises.
what's the date on this video?
6/26.
Looks like 6/25.
Was it 6/25 or 16? I'm sorry, 6/25.
6/25, 16/23/05, so at, would that be 24 hour clocks?
Yeah.
12:05, right?
11:05 p.m.
11:05 p.m. Okay. And who is this supposed to be?
This is Officer Michael Roberts entering our premises.
All right.
We have no objection.
All right. The still shot from the videotape will be his second exhibit. All right, please continue, Mr. Pendleton.
I do have a witness also that can verify that Michael Roberts came to the location.
That won't be necessary at this point because
Okay.
we've already admitted the photograph.
Okay, no problem. Thank you, Your Honor.
And Your Honor, we'd be happy to stipulate that Officer Roberge visited the location at that time.
All right, very good.
At that time, Officer Roberts did not write a citation. We requested public records. I showed you a copy that was received yesterday. There were no public records of a dispatch, a complaint call, or anything on Spokane Public Records for Officer Roberts' visit on 6/25. A visit that came promptly after an appeal was filed in this matter. This is more proof of the unwarranted harassment this business has had to go through. Respondent officers and city officials are the only ones in the respondent brief that are reporting this activity. The officers are the only ones that have an issue with this activity. Public records clearly show Officer Roberts dispatched himself to open an incident report on this issue. I've submitted a copy of that. The respondent brief only appears to show that SPD officers were targeting this minority business looking for a reason to deny. A Daiquiri bar operating a licensed cafe is not required to have an entertainment license. It can clearly operate without one. As an example, our neighbor, Mod Pizza, they play music from speakers mounted outside above its patio. It's not detrimental to serving pizza, but they do it. They are exempt from entertainment licensing. The only reason for denial, the respondent officers, is the appellants had not been issued a new entertainment facility license before these reported events. The respondent cannot deny that the applicant did apply for the permit. The respondent cannot deny that the applicant fully qualifies for the renewal. Michael Roberge, prior to the renewal application, has already stated his bias against the business and emails an objection to the liquor license of the business on May 3rd. That email is subject of a City of Spokane ethics complaint that was filed May 30th. This is a copy for the record. Inside that ethics complaint contains,
All right, can you hold on one second?
Okay.
Pendleton?
Your Honor, the city objects to the admittance of this ethics complaint form as being irrelevant. It's a separate procedure, separate proceedings. Any information that is in that is here could be separately admitted.
All right, Mr. Pendleton,
Your Honor.
when was,
if-
hold on.
Okay.
When was this complaint filed?
It's got the file date stamped on the front, Your Honor.
June 30th?
That's correct. But if you look inside the complaint, Your Honor, you'll see the email written by Michael Robridge on May 3rd that establishes his frame of mind about the business before the application
Okay.
for the license was even filed.
All right, hold on now. The May 3rd email is already part of the record, is it not?
No, it is not, Your Honor.
Before I get into this, what's the May 3rd email about?
The May 3rd email is his objection to the liquor licensing of the business, where he used statements and he used data that does not match the public records, and he wishes to paint the business as a nuisance when the business has never been cited by Spokane Superior Court or a police chief
All right,
of Spokane as a nuisance.
Okay, let's stop there. I agree with Mr. Folsom that the ethics complaint itself should not be admitted. The other documentation that you're submitting with the complaint can be admitted one at a time, depending on whether it's admissible. So
Thank you,
you can
Your Honor.
present each of those as you go.
Okay, thank you, Your Honor.
All right, so
I can
let's,
separate them.
let's separate them and do one at a time of the documentation that you want to submit.
Okay, thank you, Your Honor. Okay, the first document that I am going to submit is an email that was originally written by Michael Robridge on May 3rd. It was forwarded to fellow officer Ernest Withridge, who replied nicely stated. Then Michael Robridge forwarded this to City of Spokane permit officials. In this document, he states he wants to paint the picture of the Daiquiri factory shows a pattern of being a chronic nuisance. In this document, he cites the incorrect address. In this document, he cites 63 calls from police in a 3-month period. Of these 63 service calls, 35 specific crimes of assault, disorderly conduct, and fights happened. All of this is incorrect information, so I'll submit this first.
Okay, thank you. Folsom, same question. Any objection to admission of this document?
No, Your Honor.
All right. The email will be admitted as Exhibit 3. All right, Mr. Pendleton, what's next?
Okay, the second email is a Spokane Police Department record request requested on June 8th. Attached is the service call information for the property, which is at 121 North Wall Street. This is the correct location of the establishment. These are all service calls from the time period of January 20th to June 2014. And the total of service calls on here are 53, 1 duplicate, and 1 cancel. So those public records are to dispute Officer Robridge saying that there were 63 service calls in the 3-month period, when public records say there was only 53. It also disputes Michael Robridge's statements that there were 35 crimes.
No objection.
All right. So the cover email and attached service records will be admitted as Exhibit 4.
Your Honor, I'm submitting those documents to show that Michael Robridge was already biased against the business before we even applied for the entertainment license on May 31st. Those statements, written in inter-office emails, are a subject of another complaint filed with the Ethics Commission on the same matter. These emails were first forwarded by Michael Robridge to city official Katie Schaefer. Katie Schaefer printed these emails out and provided them to local news press. And those documents prove that Michael Robridge emails were printed out. The letterhead and the picture in those documents show it's Katie Schaefer, which is the city a Spokane permit official. I'm not sure if she works in the same office as Ms. Red, but they are all CC'd on the email. They
You
were
are
all
right.
aware. They were all aware of these. They were all aware of these documents before we applied for our entertainment license.
The city objects to the admission of these photographs, Your Honor. The documents that are photographed are already part of the record and have dates on them.
No, they're not. The photographs in the photographs in that record are emails from Katie Schaefer. They're not in the record. Those are photographs of the documents printed.
All right, hold
From her.
on, Mr. Pendleton.
Okay.
Not gonna do this KHQ bulletin. This actually is already in my file.
You do have that in the
Along
file?
with correspondence from Katie Schaefer, so I already have
Okay, you do, Your Honor.
the
Okay.
relevant portions of communication, so I don't need to admit these.
Okay, thank you, Your Honor. Those emails by Michael Robridge and Katie Schaefer appeared on the news, coincidentally, the same day after Michael Robridge wrote the objection in the exhibit that I gave to you previous. At that time, those statements that are false on the record was not a matter of public record until June 6th, when the city actually sent them to the Liquor Control Board. And that's the letter of the city, including Michael Robert's statements that went to the Washington Liquor Control Board. That's a matter of public record. Those items were retrieved from the Liquor Control Board public records request.
Any objection to this document?
Hold on.
All right. The June 6th letter from the city planning and development department to the Liquor Control Board will be admitted as exhibit number, is that 5? Am I counting right? All right.
Again, I'm submitting this as evidence to show prior to us applying for the entertainment license, there was already bias amongst these city officials. If you look into the incident report that Michael Robridge turned in and swore under penalty of perjury, he cites immediately after the entertainment license was denied, he let the Liquor Control Board know. The current denial of an entertainment license has nothing to do with the Washington Liquor Control Board. But in an effort to continue to show bias and propaganda and paint the picture to state authorities that the business was doing something illegal, he immediately notified the Washington State Liquor Control Board of denial of the entertainment license. He did not notify them that the license was applied for properly or that the business could clearly operate without one. Again, extra
I'm
effort.
Sorry, Mr. Pendleton, I don't mean to interrupt, but I'm looking at the report that you're referencing, and I don't see where Officer Rivera is
Okay.
notifying the Liquor Control
Okay.
Board. If you could point that out.
6/15/2016 on the incident report. I notified the Washington State Liquor Control and Cannabis Board of this denial and the ongoing violations that have never been written and are not on the record.
Well, I don't think you're reading the incident report. You must be reading the.
I am reading the incident report that Michael Robert submitted already yesterday. This is the incident report.
Okay.
Incident report 16-215781. I certify and declare under penalty of perjury under the laws of the state of Washington that the foregoing is true and correct. M.D. Roberts, he's the one who wrote this incident report.
Thank you, I see that.
He did not notify that the license was applied for properly or that the business could clearly operate without one. Again, extra effort to keep the business closed. These actions are not listed anywhere in the municipal code, but they are indeed actions taken by respondents as stated in the respondent's incident report. There is great effort going on here to deny entertainment license to a minority business that has had to overcome a great deal of real actual obstacles. We've been fighting for 2 years in an eviction where a landlord didn't give us a 3-day notice and put us out of business. We weren't put out of business because of the rumors you may think we were put out. We were put out because the landlord wanted to lease our property to Urban Outfitters. All right, we've had to fight real issues. We've had to reestablish our business and open immediately because we won the eviction. In order to establish our damages, we had to open up immediately as soon as possible, so when we sue for damages later, we can show the federal judge that these are the damages occurring from the wrongful eviction. Before the wrongful eviction, we had all our licenses, we were operating business, our landlord wrongfully evicted us, the judge awarded us the keys back, we opened up immediately as soon as we could. The respondent wishes to deny this right based on the actions done after an application with no issue to deny was clearly made, applied for willfully, in good faith as required by Spokane Municipal Code. The respondent claims that the business was notified by the city treasurer, but nowhere in the municipal code does it state that a business can be notified to comply by voicemail after it is clearly applied for the application and are awaiting it. At no time did the respondent notify the business to stop by Spokane Municipal Code. No citation was given. Only the surveillance by multiple officers cited several times inside this incident report submitted by respondent. No officer wrote a citation. No incident report or call came in from the public. No calls were made to Spokane Police Department as complaints. We requested public records. The only public records for the month of June are the ones I've submitted for the business. The only complaints being noted in this respondent's brief are from the officers themselves. Going through the record, June 7th, yes, we were open. We opened because it was the first day after receiving our approval from the city of patio and health approval. We received our sidewalk patio permit and final approval from the health department on the same day. So yes, we did open on June 7th. We were open for business. Great concern is in the incident report when he's citing his witnesses. Everybody's so concerned that we're open. Well, we had the right to be open. We have a business license. We have fire approval. We have occupancy. We have health. We have sidewalk permit. Now, we don't have an entertainment license yet, but nor do we have liquor approval yet.